The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Expert show where we bring you the finest experts in the field of legal, health, financial, and home improvement. We are so excited to have you on our show today. We have got a great guest. I got to tell you, I was at a party the other night, and a lot of people were within a community association. And I got to tell you, I mean, it must have been 30 or 40 people there. Everybody talked about things that were going on in their association. And, you know, we know that this show topic, community association, is one of our strongest show topics. But when I was at this party the other night, that's all people were talking about. Just different things going on in their community. Well, we have one of the greatest attorneys on with us today. She is from K. Bender Rimbaum. They have offices in Palm Beach, South Florida, Tampa, Orlando. And Kirsten's now been with us, for about 6 or 7 months, doing such a great job. And we are going to talk about community association law. Welcome, Kirsten. How you doing?
Hello, Steve. How are you?
Oh, I'm doing wonderful. This is just such a great topic. When I got into this business 12 years ago, I never knew how important community association was, but it is in every one of our markets, our top show. We're so glad to have you. Tell people about K. Bender Rimbaum.
Sure. So K. Bender Rimbaum is a community association law firm. We only represent condominiums, associations, homeowner associations, and cooperatives. Our main office is located in South Florida in Pompano Beach, but we do have other office locations in Palm Beach Gardens, in Orlando, and then on the West Coast, our office is located in Tampa, and I'm the managing attorney of the West Coast office.
Well, I got to tell you, I love this. Is probably one of the easiest shows to do. And what we do is we take text messages and emails from listeners and viewers every day, and every day we get at least one. And you all send us such great questions. And that's what we do. We feed these questions to Attorney Kirsten. And I hope we get your question on today. We got a full show. We're going to start off with Jill in Eastlake. She says, our condo association pays a management company $28,000 a year. And we paid the past president, which Kirsten, I've never heard of this before, $35,000 a year as a liaison. We have 75 condos in our association. Is this even legal? I guess she means about the $35,000 a year to the liaison.
Agent director. Yeah. I mean, I'm not sure what liaison is. I'm going to have to presume that there's some kind of service agreement or contract between this former president and the association, or there should be. I mean, certainly this creates a conflict of interest, right? If he is a if he was on the board and providing some kind of service. Now, the condominium statute doesn't prohibit, contracts between directors and the association, but there's certainly a process that needs to be followed in order to approve these types of service contracts. So if you do have a director or officer or a family member or relative that resides with an officer or director that's providing services to the association, then the first thing is that this service contract should be reflected in the agenda of a board meeting at which the contract has to be discussed in an open board meeting. Obviously, the interested director or officer that's providing the service would have to abstain from any voting, and the service contract has to be approved by 2/3 of the other directors. And then what most boards miss is that the contract has to then be presented to the membership at their next meeting. So the membership does have the ability to reject the contract if they wanted to by a vote of the majority of the members. Okay. Now, ultimately, if this process is not followed in order to approve this service agreement between a director, officer, and the association, then the statute says that the contract is voidable. Okay. If a notice of termination is presented to the board by if the notice of termination has been signed by at least 20% of the membership. Okay, so if 20% of the membership consents to terminate this contract and they present that petition to the board, then that contract would be deemed voidable.
Have you ever heard of
it's illegal? It's just that. I'm sorry. Say that again.
Have you ever heard a community having a liaison?
I personally have not, but I learn new things every day on this job.
Okay. When I saw past president, liaison, whatever they want to call it, I was like surprised. That's one I've never heard of before. But let's go on to Vince in Tampa. What does the Architecture Review Committee do? Are they more powerful than the board?
I don't know that there's anyone more powerful than the board. But an architectural review committee essentially receives requests from owners for architectural change, whether it's in a condominium association or homeowner association. So there's typically some architectural request form that an owner has to complete if they want to do changes, whether it's within the unit or in a homeowner association, typically to the exterior of the lot. You'll fill it out and then you present it to this committee. The governing documents of the association will typically outline, who comprises this committee, whether it consists of just directors or whether board members can also serve. It would typically also set forth the process for appointing this committee and their functions, which typically is to review these architectural requests and then approve and disapprove them based on some kind of documented basis. So typically there will be specifications that the board or the committee has approved in advance. For example, if an owner is looking to replace windows or doors, the board should have hopefully adopted some kind of specifications as to the type of door or window that they will allow. Or for homeowner associations, if an owner wants to paint the exterior of a home, hopefully the board has adopted a color scheme of colors that they would allow, and then it's up to the committee to make sure that the application's complete and that the proposed alteration meets the specifications. And assuming it does, the application would be approved. And if it doesn't, then the committee would identify the basis for the disapproval.
We're going to go to Sylvia, who's been a long time listener. She's in Plant City. What can I do if the association isn't keeping up with maintenance? I thought that was in our docs, and the association must take care of this. We get a lot of letters about landscaping, maintenance not being kept up with, and what they can do. So this will represent a lot of those letters that we got.
Yeah, so I mean, I'm not sure if Sylvia's in a condominium or homeowner association, but typically the governing documents will identify what the maintenance obligations are of the association, which typically is done through the board of directors. And the board of directors hires the appropriate vendors to, maintain and upkeep the portions of the community for which the association is responsible. So for HOAs, you're right, Steve, typically would be, landscaping and recreation facilities, whether it's a clubhouse, a pool, and similarly for condominiums, exterior landscape, and then obviously all the amenities. But if the association is not properly maintaining the common elements or common areas, I would say, start with notifying the property manager. Don't go directly to the vendors, because obviously these vendors don't have a contract with the owners. They don't represent owners, right? Their contract is directly with the association. So they really shouldn't be, discussing maintenance issues directly with the vendors. They should address them with the property manager or the board. Hopefully that resolves the issue, and the association, will address it with the vendor. Because you might not. It might be an issue that the vendor is the one that's not doing what they're supposed to in accordance with the maintenance contract. Right. It might not even be, fault of the board. So I would address it with the board and management directly. And that depends on what the circumstances are. If the board is just neglecting their fiduciary obligation to maintain the common areas or common elements, then, the owner might want to consider consulting with an association attorney, an independent attorney, perhaps sending a demand letter to the board, just, letting them know that they're, potentially breaching their fiduciary obligation, and, they should get to it and maintain.
I noticed one of the letters that we got that the association was in charge of, I guess, mowing the lawns once a week. And all of a sudden they cut it back to once every 2 weeks. Are they allowed to do that?
Well, hopefully the governing documents give the board some discretion in maintenance, right? Whether it's landscape or if they have to pressure clean roofs, right? It's up to the discretion of the board how frequent to undertake certain types of services, right? Depending on the necessity. But I think the bottom line is that if the board feels that 2 cuts or 1 cut every 2 weeks is sufficient to still maintain the same standard and level of maintenance, then they have the business discretion to make that judgment.
Okay. We're going to go to James in Citrus Park. If the ARC denies my request, what can I do? Do they allow an appeal?
Well, whether an ARC or this ARC committee allows an appeal, I mean, that would have to be, that's document specific. But I would say, take a look at the reason of the denial. If it's a document that was missing, maybe some plans were missing, or maybe the board requires copies of permits. That's something that's easily fixable. If the denial is something related to, it doesn't meet, the request doesn't meet the specification standard, that's different. I don't know that the board will, change their mind if you can only replace your door with white and you want a black door, right? Unless the board hasn't uniformly enforced the specifications, in which case you might have a basis to, further appeal or, challenge the decision of the board. But in terms of like a formal appeals process, I mean, I would check your governing documents.
So we get a lot of letters, people complaining about different rates that are going up. And I want to say people don't always know all the different costs that are involved in a community. And I have a restaurant show, and we're very much into restaurants and what goes on inside a restaurant. Everything is up. I mean, little small things like ketchup, everything is up. And I know some of these people are on fixed incomes, but it's not the association's fault for all these rates going up, especially when it comes to insurance. Do you agree?
I agree, Steve. And unfortunately, the board does have a fiduciary obligation to make sure that the common elements are maintained, that the association is protected. And so if costs go up, they're going to have to adjust the budget to meet the needs of the association. It's just one of those, it is what it is situations, yes. Unfortunately.
Let's go to Connie in Tampa. If we have money left at the end of the year, can we put it into the reserves? I think it should be given back to the owners. Your thoughts?
Well, I've not come across many associations that have a surplus. They've had a surplus at the end of the year. I mean, that's just, I haven't seen that lately. So if Connie's association has a surplus, I mean, that's fantastic.
Yes.
But typically a surplus, it's would just be rolled over to the next year's budget. It would basically reduce the assessments for the owners. So it is going back to the owners. It's not going back, in form of a check made out to the owners. Okay. It's just applied towards the assessments that would be due the following year. So the owner's assessments would be, effectively reduced, even if slightly.
I think one of the greatest things that Kay Bender Rimbaum does is you really believe in education. Your whole firm gives so much of their time, just like a program like this, educating people. You've got a lot of classes coming up the month of May. Can we go over those?
Sure. Yep. I have the scroll in front of me. We actually have a new course called Milestone Inspections and SIRS. So it's going to be taught as a webinar by our fellow Orlando-based attorney, Alan Schwartzite, and that's going to be May 9th. Again, that's via Zoom from 11:30 to 12:30, and it is offered for a credit for those CAMs still looking for credits. Then we have a lunch and learn on May 21st. And that one's going to be Michael Bender, one of our named partners. He's going to be teaching a course on conflicts of interest. So I just talked a few minutes ago about a conflict of interest with that one director providing services to the association. So Michael's going to go just a little bit more in depth of what a conflict of interest is. So that's May 21st. Then we're doing another milestone inspection and SIRS webinar on May 23rd. So for those that can't attend the May 9th one, there's again a webinar on milestone inspections and SIRS on May 23rd from 10:30 to 11:45. That's also going to be taught by Michael Bender. Alan is actually teaching a board certification class for homeowner associations governed under Chapter 720. So if you've been recently elected or appointed to your homeowner association board and you're looking to get your certification, then this is the class to attend, May 24th, 10 a.m. to 12:30. That's also going to be via Zoom. And then Michael is also teaching another conflict of interest class May 29th from 12 to 1, also via Zoom.
Busy month.
It is every month. And I encourage, the listeners to go on our website. Every month we list a new calendar of new courses that we're teaching. And so just, regularly check our calendar on our website. Seems like next month is going to be heavily based on milestone inspections and conflict of interest, but we certainly offer plenty of other courses on, very different topics. So
Give everybody the main number that's good for all the locations.
Yes, our main number is 954-928-0680. It is our Pompano office number, but the receptionist can just transfer you to any attorney in any location by a switch of a button. So
We're going to go to break, and we come back. We have more with K. Bender Renbaum. We'll be right back.
K. Bender Renbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Renbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Renbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Renbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the last Tuesday of the month. That means K. Bender Renbaum. And we are so glad you've tuned in today, and we hope we'll answer some of your questions. If you want to text us questions, you can text us at 954-336-3767, and we will try to get your questions on air. We do our show 3 times a month. We have an Orlando show. We have, as of today, we have our Tampa show, and we have our South Florida show. We're here with attorney Kirsten Hens, and we are, I guess I got to say that, here's a show you can ask an attorney, doesn't cost you anything, and this is a great time to ask your questions to an attorney. Kirsten, we're going to go to, let me see who's next here. We're going to go to Brad in Land O'Lakes. Says, my condo will have the first owners meeting this year. Owner has the right to attend such meetings, includes the right to speak at each meeting. Does this apply to renters?
Okay. So it looks like Brad is having their seems like annual meeting, but in any event, a membership meeting. So, typically it's owners who attend, who are entitled to attend membership meetings and to obviously speak as to any designated agenda items. That right doesn't necessarily apply to renters unless the board wants to allow them in. Certainly if an owner has a power of attorney giving that right to a renter, I mean, you'd have to, review the power of attorney to see what rights that renter has. But typically, no, renters don't just automatically have a right to attend a membership meeting.
I was wondering about restaurants. I noticed some of the associations have one restaurant, some might have 2 or 3 or 4 restaurants. Is there something in the docs that say they have to have one restaurant per how many units? I mean, how do they decide how many restaurants they're going to have on property?
That's interesting. Well, I mean, typically the way I've seen it is, restaurants are held what is known as a commercial unit. So you might have a condominium that has residential units at top, and then, the first floor would be commercial units, and then you might have a restaurant, you might have, a wine bar or some other, retail space. So typically those spaces, or they could be commercial units. I mean, the declaration of condominium would specifically speak to that as to, how many commercial units, what even the commercial units can be used for. I mean, the declaration might even prohibit certain types of businesses from being operated in those spaces. So that would all be dictated by the declaration of condominium.
Okay. We're going to go to Florence and Tampa. If a board member resigns, does the open seat have to be filled by the members that ran for the board but did not get elected?
Okay. No, I mean, the short answer is no. So typically, it's the majority of the remaining directors that get to fill the vacant seat. Who they want to appoint for the vacant seat, typically, business decision. I mean, that's certainly an option to appoint that seat from someone that, was a candidate but didn't get elected, but they're not obligated to fill the vacant seat, with such candidates. I mean, they can also make an announcement to the membership to see if someone, is willing to volunteer, and appoint that individual. So they're not limited.
Okay. Robert in Tampa. Love your show. I never miss one. I just wish you were on more. You've got a lot of spare time. We have a homeowner who is delinquent. They are trying to sell their condo. Will the title company make the buyer aware of what is owed on the property?
So typically when a unit or a home is being sold in the community, there's going to be some estoppel request made on behalf of the selling owner. So typically that's a title company that will submit a request for estoppel to the association through management. And that estoppel request will include information about any delinquent assessments or any special assessments, as well as request any information about, existing violations. Okay, so I guess the short answer is yes, the title company will make this request, and then the association through management or through legal counsel can fill out that request and then submit it to the title company. And if there are any delinquent amounts due, then they should be addressed, prior to closing.
Go to Stephen in Tampa. I'm a board member and I love your show. All my board members listen to your show. You got to stop getting your family to call in here person. No, we have townhouses. We are responsible for the roof repairs. Our roof is 30 years old. Is a 30-year-old roof insurable?
I mean, that's a good question. I think that question is better directed to the insurance agent for the association. You know, the insurance companies, you know, have their own criteria as to what they insure, what they won't insure, the life expectancies of the roofs that they will insure, and so I think that's a better question for the association insurance agent.
Okay. Let's go to Peter in Tampa. Our condo association wants to do a special assessment. Don't they have to post it? There is nothing discussed about it.
Yes. So if an association wants to adopt a special assessment, and this applies both for condominium and homeowner association, then yes, the board does need to provide the membership with advance notice of the meeting at which the special assessment will be adopted. That notice has to not only be posted, but mailed to the owners at least 14 days prior to the meeting. For those owners who have consented to receiving notices from the association by email, that notice of the board meeting can certainly be emailed to those owners. And yes, the notice then also has to be posted in a conspicuous place on condominium or association property at least 14 days prior to the meeting. And then both statute also require that the notice identify the purpose of the assessment, and identify the amount, at least the estimated amount of the special assessment. And then once the board adopts the special assessment at a board meeting, they have to notify the owners of the adoption, and then how much is each owner responsible for, which is going to be determined, based on, the governing documents.
Let's go to Dan and Brandon. We are in a condo, and the board of directors has decided to build a tent for termites, and they want the owners to leave their building for 3 days. Several do not want to leave their units. What can the board do to get them out for the 3 days?
Oh boy, I don't know who would want to stay inside a unit while it's tented.
That's
the
first thing I thought.
Certainly get your association legal counsel involved in this. If you've sent the owners, notification of the tenting, and they are still, refusing to leave, I would get the legal counsel to send a demand letter, essentially, to force them out of the unit. And if they don't, then this might be a situation where you might have to proceed with further legal action, whether it's, mediation, arbitration, and hopefully it's resolved at that point before having to file a lawsuit.
Let's go to Lenny in Tampa. What authority does an HOA board have to tow cars parked on common area street? Do they need to post a 24-hour notice on the car, or just a notice in front of the HOA?
So the authority for an association to tow vehicles from the community, that would be set forth in your governing documents. You don't necessarily need express language in the documents authorizing associations to tow, but you certainly have to have the authority, the ability to enforce vehicle restrictions or rules concerning vehicles. So as long as there's some authority in the governing documents allowing the association to enforce vehicle restrictions, then the association has the ability to enforce it through towing. Now, Florida statute on towing is very specific as to the notification requirements, and primarily you either need to have certain types of signage posted at the entrance of the community and then throughout the community, or the association would have to, mail some kind of notice in advance of towing. So, and then the association also has to have some kind of contract with the towing company. So I would suggest either getting a copy of the statute, the towing statute from the vendor, from the company, or if you have association legal counsel, have them forward to you the statute so you can see what the signage requirements are. And typically the towing company, will even provide you with the signage that you need to post throughout.
Oh, Kirsten, it used to be if someone had a one-bedroom condo that was using one person living there, one car. But now with the economy, you might have a one-bedroom condo and you might have 2 or 3 people living there and they all have a car. And we get a lot of letters. People are upset about their parking situation. I don't know why they don't do assigned parking, but people are really upset not being able to park anywhere close to their condo.
Well, I mean, the authority to assign or reassign parking spaces, that has to be set forth in the declaration. Typically most condominium associations have in their declaration that, at least, every unit is assigned at least one parking space. Now, whether the association can accommodate these owners with multiple vehicles by assigning them additional parking space, that would be dictated by the governing document. So, they would have to look at the declaration and then, speak with their association legal counsel as to what they can and cannot do. And sometimes, and we've done this for clients, sometimes we have to amend the declaration to give the board this additional authority to assign or reassign parking spaces to accommodate these multiple vehicles. But also, spaces that are not assigned are typically, they're still considered common elements. And then I would check with the association rules to see, what they say about, the use of these unassigned parking spaces.
I would think that if they just put the unit number on there and sign it to them, it would make it easier. But apparently a lot of them don't do that. It's just wherever you want to park. But we do get a lot of letters about that. Let's go to Craig in Tampa. I'm on the Rules and Regulations Committee at our condo. We are making recommendations to the board on updating them. Do we have to open our meetings up to the residents?
So typically committee meetings are still, subject to the notice requirements. So, you'd still have to typically post notice of these committee hearings, 48 hours in advance. And yes, they're typically open to residents.
So, for example, the next question from another viewer says we have a separate finding committee. Do they have to open up their meetings to the residents also?
Yes, I mean, finding committee hearings or grievance committee hearings, I mean, they're typically, yes, they're open to the membership. They have to be duly noticed and open to the membership. Yep.
Justin in Tampa, who's in a condo, wants to know, when can the association foreclose on an owner? I'm sure that's in the docs too, right?
Well, the association has lien foreclosure rights, and typically they come into play when the owner has been delinquent on assessments. There's a statutory procedure before you can even foreclose, and typically that requires a notice of late assessment to be sent to the owner, typically by the association or management company, which gives the owner at least 30 days to pay the delinquent amount before the unit is turned over for collections. And then, presuming the owner doesn't pay and the unit is turned over to legal counsel for collections, then the attorney has to send a pre-lien letter, and that's in the statute, giving the owner at least 45 days to pay the delinquent amount before a lien can be filed against the unit. And then if the owner still doesn't pay, then the association has to send another 45-day notice of the intent of the association to foreclose before they can file the complaint or the lawsuit for foreclosure. So at least you've got to send at least that the initial 30-day notice of late assessment plus the 45-day intent to lien letter plus another 45-day intent to foreclose letter. So the association wouldn't be able to foreclose at least until all these notices have been sent out.
So a person's given a lot of opportunities.
Yes, and so imagine those boards that don't immediately take action, with their notices of late assessment, and they give the owners, courtesy notices, and then maybe a second courtesy notice before they even start the process. So it could be, sometimes up to 120 days before you can file a foreclosure action.
Wow.
So the bottom line is don't sit in a delinquent account. Be proactive.
Peter, in Tampa, our board is creating a dozen new design standards, exterior paint, landscaping, etc. Do they need a vote from the homeowners to enact these new standards? Is anyone grandfathered?
So typically these types of standards or specifications are, within the discretion of the board to adopt. Now, having said that, I would recommend confirming with the governing documents to make sure that that's in fact true. There could be, and I have seen instances where membership approval is required on certain types of rules. Okay, so just confirm that membership approval is not required. Assuming that the board can adopt these specifications, if they concern obviously the home or the unit, the notice of the board meeting at which the specifications or standards will be adopted would have to be mailed to the owners at least 14 days prior to the meeting at which the standards will be adopted. And then the notice has to be posted at least 14 days prior to the meeting as well. So it's not a 48-hour notice, it's a 14-day mailed notice to the owners. And then probably the more important part is once these standards and specifications are adopted, you have to send a copy of them to the owners in order for them to become effective. And typically these types of specifications and standards apply prospectively, so from the date of adoption forward. So you wouldn't apply them retroactively, but rather going forward.
Okay. Let's go to Larry in Land O'Lakes. HOA are amending their documents to allow capital contributions. Can condos do the same?
So with capital contributions, with condominiums, the division has taken the position that they are considered a transfer fee. And so in the condominium setting, they would not be allowed. Typically, you will see capital contribution requirements in homeowner associations, but not in the condominium setting because of what I just mentioned, the position that the division has taken. So with condominiums, you're only entitled, or you're only allowed to charge the $150 application fee in connection with the sale. Nothing else.
Let's go to William in Tampa. Can you explain voting certificates?
Yes, so voting certificates would apply if a unit or home is owned by either multiple individuals or by an entity. Typically, if a unit or a home is owned by just a single individual, then that individual would be the only one that can vote on any issue pertaining to the community, right? One vote per unit, and that individual gets to vote for that unit. With units that are owned by multiple individuals or entities, the voting certificate typically designates which among the multiple owners or which representative of the entity can vote for that unit. They can designate among themselves who's the one that's going to cast the vote. So they'll identify, the husband or the wife. Typically, it will require the signatures of all the owners, and then that gets filed with the association. In the case of an entity, the voting certificate will designate, who is the authorized representative that can vote for the entity. Typically it's the either a director, an officer, or an authorized agent of the entity. And so how that plays out is, let's say with an election, a condominium election, the outer envelope has to be signed by the voting member for the unit. So when, let's say, on the day of the election, all the exterior envelopes are verified. If the association has been enforcing voting certificates, right, then the management or the volunteers who are verifying the envelopes will compare the name on the outer envelope and the signature with the voting certificate. So let's say for Unit 100, Bob Smith is the one that's the authorized voting member based on this voting certificate, and Johnny Smith signs the outer envelope. Well, the association could have a basis for disapproving that vote because it was not signed by the voting member authorized in the voting certificate. Okay, so that's how voting certificates typically play out. And it really will depend on what your governing documents say about voting certificates. I've seen documents where husband and wife they don't have to fill out a voting certificate. Okay, they can just decide among themselves. And the governing documents might have specific criteria as to who can vote for an entity. Sometimes it's limited to just the officers and directors, so nobody else can vote for an entity. So very document specific as to whether the association even, has the ability to enforce voting certificates.
Well, Kirsten, believe it or not, we have come to the end of the show. As always, what a great job you've done. Give everybody the number at K. Bender Rimbaum.
Yes. The main number is 954-928-0680. And you can call that number and get a hold of really any attorney in any office location.
That'll do it for us today. We'll be back again with you next week with more Ask the Experts. Again, thank you so much, Kirsten.
Thanks for having me, Steve.
And that'll do it for us. We'll be back with you again next week. Thanks for tuning in, everybody. Thank you for your questions. We'll start taking again next week. We'll take your phone calls also. We appreciate you taking the time to write us. Everybody have a good week. We'll see you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk 4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.